Hello and welcome to the Arbitration Conversation. So in this episode, we have somebody who I have admired in my whole life. I mean, I remember reading his work way back when as a young lawyer and then early on as a professor. And then lo and behold, I actually ended up on the same faculty with him, which is awesome. So who we have today is John Lande. John Lande is the Isidor Loeb Professor Emeritus at the University of Missouri School of Law. He's also a fellow with the Center for the Study of Dispute Resolution at the University of Missouri. And he has written so many books and articles that there's no way that I could list them all because then this would be much longer than a short podcast. But instead, we want to focus on his most recent books. So one of his books, it is Lawyering and Planned Early Negotiation, how you can get good results for clients and make money. Also, most recently, he has written about litigation interest and risk assessment, help your clients make good litigation decisions. This book he co-authored with Michaela Heat and Heather Haven. So I probably messed up that, but John,
Yeah,
hopefully
right.
we can work it out, right? So John, first of all, thank you so much for being here. I mean that wholeheartedly. You're somebody that I have looked up to, who I believe is one of the most influential dispute resolution people out there. And I'm just super thankful for you to take the time to talk with us today.
Well, I'm really appreciative to have the chance to talk with you and the viewers, and I appreciate your very, very kind words.
So as we start off, I mean, obviously this is called the arbitration conversation, but part of that is really where does it fit in a dispute resolution strategy and in really solving problems, which of course is the ultimate goal. And so in your book, I know you address some of these things. So what was kind of the main point of your most recent book?
Well, there are a couple of main points. One is that parties and lawyers often make bad decisions when they go to trial. There are a number of studies that have been done that found that in about 2/3 of the cases, or sometimes more, one party or the other makes a decision to go to trial and they get a result worse than what the other side's last offer was. So if you were my opposing counsel or my counterpart lawyer and I'm representing the plaintiff, and you offered me $100,000 and we go to trial and I get a $50,000 verdict, that's a bad result from my perspective, because I would have been much better off to accept your $100,000 offer, not spend the time and money to continue litigation, go to trial, and have all the hassle and stress and anxiety that goes along with that. Now, that isn't always a mistake necessarily, because let's just say I had a 90% chance of winning more than $100,000, and it just so happens that this was one of the 10% of the times where it was where I got less than that, but still it's a very bad track record. So the first thing is that we know from empirical research, replicated studies, that parties make bad decisions to go to trial, and we wanted to understand why they did that and to help parties and lawyers make better decisions. And really what this book is about is to help make better decisions. And so there are a number of reasons why people make bad decisions. There are all these cognitive and motivational errors. There are social biases that lawyers and clients don't necessarily want to be candid with each other. There's an over-optimism orientation. And the other main thing that we provide for in this book is a framework for analyzing cases in disputes. And there are three elements to it. One is the expected outcome if you go to trial, or in arbitration, what the outcome would be at the arbitration hearing. A second are the tangible costs, the litigation expenses and the legal fees. And the third one are the intangible costs, which could be stress, it could be loss of opportunities, reputation, loss of relationships, a whole laundry list of things that people, just a process creates costs that really are important. So those are some of the main points of the book.
Because what I really love about the book and why I think it's really important for practitioners to read is because you provide really sort of practical insights for an attorney as they're in the midst of working with clients with respect to litigation or arbitration. Maybe you could speak to some of these sort of practical pointers, which I think are tremendously important when it comes to actually providing value for your clients.
Sure. Well, I mean, really the key thing is for lawyers, and this book is written primarily for lawyers, also to some extent for mediators, not so much for arbitrators, but really for lawyers representing parties in cases that may go to trial or arbitration, is to do a systematic analysis. And what the book provides and describes are things that most lawyers generally do anyway, but not necessarily thoroughly or systematically or explicitly. And so what the book provides is a framework for doing this assessment by the lawyers at the outset. It's really important to do an early case assessment, which is also known as good lawyering, and then to have a good conversation with the clients about it, which is a lot harder than it may look, and then to make a plan based on that. And it's particularly, I mean, it's hard for lots of reasons, one of which is that the outcome in trial or in arbitration is extremely uncertain. And so part of what the lawyer needs to do is to think that through and talk that through with the clients. In arbitration, it's maybe particularly difficult because there is less doctrine, so the lawyers don't have bodies of statutes or case law generally that they can rely on, and there's often less discovery. And so the lawyers in an arbitration hearing may be flying blind or blinder than they are if they're going into litigation. And so it makes it harder to make an estimate in terms of what one should do, and particularly in terms of thinking about negotiation or bargaining in the shadow of arbitration, which I'm borrowing the title of a recent article by our friend Jill Gross. It's a lot harder if you don't know, if you have less confidence in what the outcome would be in arbitration. And so part of what you need to do is to try and make that assessment. And one of the risks of that is that one of the factors is the party's risk tolerance. And so if you have a party who is very afraid of losing, they are less comfortable in arbitration in general than in litigation because they have less confidence in the assessment for the reasons I just mentioned.
Right. I mean, I think though that whole sort of there are several stages I'm hearing, right? So at the outset, really sort of being very, very clear and very, very measured in establishing a risk assessment, but also understanding that the outcome could be uncertain in the area of arbitration, but also taking into account uncertainty and your ability to sort of deal with uncertainty, right? So once you kind of get through this piece, which I think is such an important part of lawyering, but something that it's easy to kind of gloss over, right? Your friends, you're kind of having this discussion, so really kind of being measured about it. But then how should that play into your negotiation strategy as you're entering in, you're sort of getting in the process, you're subject to an arbitration clause, for example. Now, where do you what about timing? Where does this fit in with the negotiation strategy?
Sure. Well, a couple things. One is that the framework that we've come up with focuses in part on the expected outcome of the arbitration hearing, and these two other factors, what the costs would be, the tangible costs as well as the intangible costs, to come up with a bottom line. So if you are negotiating, part of what you need to do is think about what your walkaway point is. So if you can't get enough, if you're a plaintiff, if the defendant won't offer you enough, or as a defendant, the plaintiff won't accept as little as you're prepared to offer, you need to have that bottom line. And so part of that reflects the intangible costs, which vary from one party to another. So part of what lawyers have to do is to elicit from the clients what their particular concerns are, because in a given case, it may be different from one party to another. So you develop a bottom line as this kind of tripwire or walkaway point, and then depending on the approach to negotiation, you may use it differently. So one of the most common approaches to negotiation, often called positional negotiation, I like to refer to the process of this counteroffer, where each side starts with an extreme offer, and then there's an exchange of offers and counteroffers, with the idea that each side's going to try and end up with the most favorable outcome that they can. So part of what you need to do is, if you start backwards from your bottom line, then you're going to think about what's the appropriate opening offer and what are the sequence of offers that you're going to make. A second approach to negotiation is what's often called an interest and options or problem-solving approach to negotiation. And there, what's involved is the parties identify what their interests are in the situation. They may identify the options, and then try and find one that would satisfy both parties. Here, doing the interest assessment that I was talking about, identifying what the intangible costs or particularly intangible benefits of the resolution may be, is particularly important, but you also want to think about what that bottom line walkaway point is if you can't reach it. There's a third approach. There's a third approach, which is rarely talked about in the literature, but from research that I've done is actually quite common. And I call it ordinary legal negotiation or norm-based negotiation. And it's where there are general norms for resolving disputes, and the negotiation is based on what those norms are. And so sometimes in commercial situations, there may be going rates or industry standards. In family matters, there may be parenting plans or child support schedules. And so the negotiation starts from what those norms are and then may deviate from one to another. And so part of what the lawyer needs to do is understand what the norms are, also have that walkaway point bottom line in mind. So it depends on what the different negotiation strategy may be, depending on what your client is interested in and what the other side is willing to do.
Yeah, that's great. I really like that, adding what you add in terms of the third strategy, because I saw that in practice in construction law, because there were certain norms that were just generally followed, but you still had to have your BOTNA or your walkaway point. One question that comes to mind, though, especially with respect to arbitration versus litigation, that I would love to pick your brain on, or maybe think about also, is when you're thinking about your interest. One thing that's often different when you're talking about arbitration versus litigation is you might actually want to litigate because you want to create precedent, versus arbitration, you don't have that same interest. Have you seen that or thought about that in terms of this strategy, in terms of maybe arbitration being an area where you're more prone to negotiate if it makes sense after you've done your risk assessment?
Well, again, this relates to the lawyer's conversation with a client about what their interests are. So if they're concerned about having precedent, of course, in an arbitration, as you point out, that's less of a concern or really no concern, whereas in litigation, that may or may not be. So that's a difference. I guess one of the other, there are all sorts of procedural considerations in terms of choosing one or the other, assuming that there isn't an option. Obviously, if there's an agreement to arbitrate at the outset, then the parties may feel bound to that, or pre-dispute arbitration agreement. But if you have a choice, then these are some of the considerations that one might have in terms of whether the client is interested in having a precedent or not.
Right. So I know that this is the arbitration conversation, but many mediators are also arbitrators. And what does your book have to say for mediators to make sure to consider?
Well, basically, it's the mediator's job is to help the parties and lawyers do their own litigation interest and risk assessment. Often they come in, if it was an easy case, then probably they wouldn't be in mediation. And often one side or the other or both have unrealistic expectations about what would happen if they went to trial or if they went to an arbitration hearing. And so a lot of what mediators do is to help parties develop more realistic expectations about what the outcome would be, and what would be helpful. And of course, so what's different is the mediator needs to have some understanding about what is likely to happen in the arbitration process, both leading up to the arbitration as well as during the arbitration, and what the likely outcome would be in arbitration. So to help the parties and lawyers think that through. And then also think about the differences in the tangible and intangible costs. So one of the differences is that there are hefty arbitration fees often in arbitration, and so you calculate that in. And what mediators should do is also think, help the parties think about what their intangible interests are. And again, often lawyers and mediators don't think about that as carefully as they should. They often don't think about that at all, and sometimes they just sort of give it short shrift. A lot of times they don't. They'll only raise it at the end to say, well, you don't want to spend the time or money. Our advice is to incorporate that as part of the discussion in the mediation relatively early on. And so a mediator might ask the parties, whether it's a case that might go to arbitration or litigation, what's most important to you in this case? Why hasn't this settled? To try and understand what the case is really about. So mediators, like lawyers, should be conflict diagnosticians. They should figure out what the heck the problem is about and then try and solve it. A lot of times they'll assume that the problem is different expectations about what would happen in court or at the arbitration hearing, and that may be part of it, but there may be all sorts of other things. So that's what the mediator should be doing, is to try and do their own assessment and then help the parties do their own assessment. Really, that's the primary thing. There's a dispute, one last thing on this, as to whether mediators should express their own opinions. And in general, our view is that in the first instance, mediators should help the parties and the lawyers do their own assessment, and then if they need it and want it, they may ask the mediator to give their own assessment, but that's presumably a last stage, assuming that the parties and lawyers want it and the mediator is comfortable providing it.
I have to say what I loved, that conflict diagnostic, to actually try to diagnose what's at the heart of the conflict, because you're absolutely right. Like there's things, for example, just having to attend a deposition might be something that really would be very frightening to an individual, such that they would not want to get that far down the road into an arbitration or litigation. So things like your time, things like your reputation, things that you cannot sometimes think about in the very beginning, but you kind of need to. And if you have a lawyer or a mediator who's helping you sort of tease out your own interests, I think it can help really sort of be a conflict diagnostic. I love that term, actually. I love that. That's great, because that's really what you're trying to do, like a surgeon, try to figure out, like, what is it? Let's get rid of that problem. Again, going back to problem solving as being the ultimate goal.
That's exactly right. And the book has 2 chapters on intangible costs, one for individuals and one chapter for organizations. And a lot of this actually comes from the research that my co-authors, Michaela Keat and Heather Haven, have done, and reading about what stress of being in a dispute, being in litigation, or anticipating going through an arbitration process leading up to a hearing, can produce incredible physical and psychological and emotional harm. And it's really important for lawyers to help their clients identify that. And so the book has these appendices to help with checklists of questions for lawyers to ask clients to help identify what the client's interests are. And there's one for organizations, dealing with their lost opportunities, or or their relationship for their reputation, the publicity, effect on their ability to get financing, all sorts of collateral consequences that lawyers and mediators can help the parties think through.
Oh, that's fantastic. I love that. I mean, I just think that's such a huge resource. The book, again, I invite everybody to pick it up on your, I assume you can get it at the ABA or at Amazon, right? Oh, there we go. Litigation, Interest, and Risk Assessment by John Lande, Michaela Keat, and Heather Haven. Wow, I mean, honestly, I think it's a huge resource for so many out there. I love the idea of checklists. I love that you're focusing on these different interests that often are overlooked. And I'm just very thankful that you took the time to talk with me today. So John, thank you. I really appreciate it. This has been truly helpful, truly fantastic. So thank you.
Well, thank you very much, and I really appreciate it, Amy.